City of Stevens Point Plan Commission meeting, recorded April 6, 2020.
We'll call the City Plan Commission meeting to order. Brief roll call shows that all commissioners are present. This is our first Zoom city meeting, so it's probably going to take a little bit of getting used to. We have Maria is monitoring the chats, so if anybody has questions or comments on the chat, you can get those to Maria, and then Maria will let us know. We have live streaming. This entire series is available on the city website. And if anybody was interested in joining the Zoom meeting, that information was provided on the agenda. So we are complying with all of the state required open meetings laws. I'm going to ask that everybody participating stay muted until you are called upon or have something to submit to the commission. And we're going to have to speak slower and enunciate as best we can for those who may have a slower internet connection. If your internet connection is choppy, you may want to stop the video first. You don't have to hang up necessarily the audio, but stop the video. Cindy's munching away. The other option is you do not need to connect through a computer to use Zoom. You can dial in on the Zoom number, the phone number, then that was provided on the agenda as well. And you can participate in audio only without using the internet for those who may not have an internet connection. I think that's all the ground rules for these meetings. I ask for everyone's patience and we will get started. Item number 2 is a report of the March 2nd, 2020 Plan Commission meeting and the report of the March 2nd, 2020 meeting of the Common Council, City Plan Commission and Redevelopment Authority on page 4 of your packet. Director Karnowski, I will let you have the floor.
Thank you, Mayor and members of the Plan Commission. Item number 2 is the report of the March 2nd and the both March 2nd meetings, the latter of the two being the joint meeting of the City Council, the Redevelopment Authority, and the Plan Commission. Staff recommends approval as presented, barring any friendly amendments for any clerical or errors that were included as part of the.
Okay. Are there any questions in regards to the director's report? Okay, any commissioners wishing to make a motion, unmute and say so.
I would make a motion to approve the minutes as presented for both meetings.
Thank you, Commissioner Cooper. Is there a second?
I'll second. It's Anna.
Seconded by Commissioner Haynes. Further discussion? Hearing none, all those in favor unmute and signify by saying aye.
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 Any opposed, also unmute and signify by saying nay. Hearing no nays, item number 2 is adopted unanimously or approved. Item number 3 is a public hearing and subsequent action on a request from Corey Keelier for a conditional use permit to operate a tourist rooming house where the owner does not reside at the premise at 133 2nd Street, beginning on page 65 of your packet. And Director Karnowski, I will let you have the floor.
Thank you, Mayor and members of the Commission. Before you tonight is a public hearing for a conditional use to allow a non-owner occupied tourist rooming house within the R3 single and 2 family zoning district at 133 2nd Street. The parcel identification number is identified within your packet and on the screen as well. Again, the property is zoned R3 single and 2 family residence. Currently, the property is a 2 family that's been utilized as a rental in both units and non-owner occupied. According to the applicant, they've utilized it as either for families or for college students. The property itself is average width about 82 feet, but is very deep, about 512 feet, if I'm not mistaken. On your screen now should be an aerial of the property. Again, you can see it's near the intersection of 2nd and Maria, just south of that intersection specifically. You can see on if you follow my mouse here, this is the whole outline of the property. Again, it's a very deep property, just shy of an acre in size. Here's some photos of the front of the property. The first one in the upper left-hand corner is straight on. The second one is from the facing southeast. And then, of course, we get an overall aerial photo here as well, showing you the depth of the property itself. Again, the property is currently being utilized as a rental, 2-family upper and lower units. I believe there's students there right now. The applicant is seeking to keep the upper unit as a long-term rental, but would convert the lower unit into a tourist rooming house. As I mentioned earlier, the lot is an average width of about 82 feet, however, is very deep at 510 feet. The area surrounding the property could be described as commercial transitional. There's some commercial properties on the corner of Maria and 2nd, and there's a mix of existing residential rentals and owner-occupied properties surrounding the property. There is one access point off of 2nd Street. Additional driveway space is east of the house, north of the detached garage. If we go back here, you can kind of tell if you can see my mouse. There is some additional parking back here. This is the detached garage, and here's the access point off of 2nd Street. This is just an overview of tourist rooming houses as they're defined within the city zoning code. Again, R3 single and 2-family residential districts permits through conditional use non-owner occupied tourist rooming houses. Again, there are the definitions. So the findings, which you'll also find in your agenda packet, that the property is owned R3, that tourist rooming houses are conditional use when non-owner occupied. The property is a duplex that has historically been rented out and non-owner occupied. The lower unit will be a tourist rooming house. The upper unit would remain as a long-term rental unit. The owner of the property resides within the city of Stevens Point corporate boundaries, and given the existing use as a rental, it's not suspected the intensity of the use will increase if one of the units is rented as an Airbnb. Based on those findings, staff, the 14 findings, I'm not going to go over each one individually. Those are in your packet. But based on those 14 findings, staff believes that those are met and would recommend approval with these conditions. That essentially the establishment of a current license is required by the state, that the owner shall register with the clerk's and treasurer's office, shall pay room tax consistent with the city's of Stevens Point Municipal Code, that the maximum occupancy shall meet with the minimum performance standards within the zoning district, parking regulations, and all applicable building codes. That the property shall be subject to an annual inspection by the inspection and or fire departments. Property should have a locally designated agent or property manager on file with the community development office, and consistent with the state's requirements that the establishment shall have a registry available on site for inspection, indicating the identity of all dates of stay, acknowledgement of operator presence or absence, and length of stay. Again, staff would recommend approval with those 6 conditions. Would recommend that we continue forward with the public hearing as required. Mayor, you're on mute.
Thank you. I want to point out that I have 4 written comments that I'll be reading into the record. And we have the meeting open to the public in the community room of 933 Michigan Avenue, of which no members of the public are present. Any questions from the commissioners for the director before we open the public hearing? Okay.
I have a question.
Yes.
I'm wondering, just based on some of the concerns I've seen, would we want the police department to have the number of the
Agent?
designated agent? Not just on this one, on anyone.
Sure, and we could do that with anyone, because if they're on registration with the city, we can make that information available to the police department whenever we need to.
Oh, okay. Yeah, just thinking that might facilitate matters in case there was an emergency. Okay, thank you.
Sure. Any other clarifying questions before I open up the public hearing? And I can see all of the commissioners except Mr. Arnson, I believe, so you could wave your hand or something if you need to speak. Okay, so before, I will open up the public hearing. Anyone wishing to offer testimony on this particular applicant is urged to step forward. We ask that you provide your name and address for the record. And I am going to read the ones that I have first. All right, so the first one is from Veronica Walker. And it says, to the Department of Community Development, I am one of the concerned parties of this proposal. My property is immediately next door at 125 2nd Street. After receiving feedback from my tenants and what was observed, I understand the lower unit is 3 bedrooms with only 1 bathroom. I find that very insufficient for non-related guests. My tenants have wondered recently why there seemed to be an excess amount of vehicles parked in the driveway, more than usual, and several on the street. Also, there has been several occasions that one or the other tenant had to call the police department with several hours of excessive noise. This is making my tenants very uncomfortable and sleepless when they need to be up early the next day. I am only guessing with the warmer weather, it is only going to get worse. The tenants there at 133 2nd Street also feel that my backyard is a great cutoff route to use heading around the apartments building on Maria Drive. With this being observed, it seems to me that this tourist rooming house has already started. Looking ahead with the fact of significant others in the mix, we're talking of the possibility of 6 people in the lower unit with 1 bathroom, and I don't believe this would be short term. Once they would be in, who would enforce it? On that note, I strongly object. Thank you, Veronica Walker. Next, we have Alderperson Kathy Dugan. Plan Commissioners, I am including here arguments and comments regarding tourist rooming house regulations. Please consider them during your discussion of the tourist rooming house at the April 6th Plan Commission meeting. First, the constituent in District 8 has a list of arguments to consider. They follow the constituent, Louis Malewski, Portage County District Attorney and former representative to the State Assembly, lives on Ridge Road, where a non-owner occupied Airbnb, the Lucas Buick residence, has been operating without license for several months. Excuse me. It goes on to list Representative or District Attorney Louis Malewski Jr.'s comments. Hi, Kathy. I spoke to Melissa before the vote to let her know I was opposed to this. I guess it sailed through. This is the issue. This is 100% single family neighborhood. This operation is essentially a mini hotel. It truly looks like a 1960s mini hotel, long, 1 story with parking in front. This is a business where the owner is not present for. So these comments that I'm reading through, I didn't look at them ahead of time, but they appear to be related to the tourist rooming house that was already approved on Ridge Road. So I'm not going to finish reading District Attorney Malewski's comments. They will be made part of the record, but it looks like every one of these is related to the Ridge Road application, which was already approved. I will continue on with Alder Dugan's comments. Second, I would ask that you consider all of Madison's new regulations to our legislation. They follow, paraphrased and quoted from the Wisconsin State Journal article. Director Karnowski has included some of these requirements, as did Planner Kearns, but not all of them. And there's a quote, Madison's Plan Commission voted 6-2 to recommend the approval of the new tourist rooming house ordinance. If adopted by the City Council, the new regulations would take effect April 15th. It goes on to talk about the new rules, require the operators to get a $100 annual permit, allows for the establishment of a violation fee between $500 and $1,000, prohibiting on renting to multiple unassociated parties unless the operator is present, Stays must be shorter than 28 days, and it goes on to quote the Madison ordinances as seen through the Wisconsin State Journal in March of 2020. Going on with Alder Dugan's comments. Third, please consider and discuss the removal of tourist rooming houses from the R2 and below zoning. These neighborhoods are typically well-established and owner-occupied. Allowing tourist rooming houses to proliferate could destabilize the neighborhoods and promote commercial activity in the area. Fourth, postpone or table the request from the Keeliers for a non-owner-occupied tourist rooming house until the Plan Commission and City Council have considered the ordinance amendments that we will be discussing in April. Finally, I ask that you strongly consider regulating tourist rooming houses in Stevens Point. They are an over-the-top form of rental, and our city's residences are already 51% rental. Because renters come and go, neighborhoods are not as stable as they could be. Because renters are not as invested as owners, they do not always care for their property, nor do too many landlords. Then it goes on to please review Alder Nable's remarks regarding the housing needs based on the city's housing study. Thank you very much for consideration in regard to further regulating tourist rooming houses. And the last one I have is from the applicant, Corey Keelier, at 1111 Minnesota Avenue. Hey, Mr. Karnowski, since I will not be available for the April 6th Plan Commission meeting, here are my plans for the conditional use permit I have applied for. The property at 133 2nd Street has been a rental unit since we bought it several years ago, but the intention is now to temporarily use it as an Airbnb, at least for the summer. I have operated Airbnbs here in town in the past, long before the state and city permitting requirements, and it has always been a great experience. The truth is that many people my age and younger are simply not interested in the expense associated with traditional forms of lodging and use Airbnb exclusively when we travel. There is a demand for more Airbnbs everywhere, and Central Wisconsin is no different. I want to offer more than the limited options available in Point for the summer months, at a time when the city needs more tourist incentives. Speaking from experience, I know the property is absolutely perfect for Airbnb boarding. Thanks, Corey. And that exhausts the comments that I had. Is there anyone else who wishes to speak on the conditional use? Who's I would? Hang on.
Tori Jennings.
Tori Jennings. I'm sorry, I can't see all of the screens at once now. So Alder Jennings, you have the floor.
I just want to test my volume. Is it all right?
It's fine.
Okay. Tori Jennings, Alder for District 1. Back at City Council, I requested that consideration be given to revising the ordinance on temporary rooming houses, and Director Karnowski has added that as an agenda item. Therefore, my first concern and my first concern is I do not believe that this application should have been on this agenda, given that the entire ordinance itself is being considered. So that's my first objection. Given this statement by Veronica Walker, I think there's real concerns about how this property has been operated, which casts doubt on how it will be operated in the future. With that, at a minimum, there should be a delay on the decision. Lastly, given the comments that the mayor just read from the applicant itself, it sounds like he has been illegally operating Airbnbs in the past. I ask the commissioners to either postpone or reject this application. Thank you.
Thank you. Anyone else wishing to speak in the public hearing? It is still open.
Yes. Cindy, can you hear me?
Alder Nabel, go ahead.
Yes, thank you. Alder Nabel, District 3. I also would like to add my views that this should be something we look at another time. Looking at the standards of what use for the use of a conditional use, one of them states that in here, the proposed proposal that has been made, they may have had their inspection, but they do not have a license yet. And so therefore, they have not followed through all of the steps that are required. And that makes me feel that this is viable to pull this for next month, because all things are not all set up on this. There's a couple other things of when it says that that it will not be, sorry, I'm going to standard 1, that it will not have detrimental use to, I'll just the short part of it is the comfort or general welfare. It's obvious it has already with the person north of that just wrote the letter. I also wanted to say that it does impede on part of, and I had sent this in, you didn't read this part, but again, our land use that we've had is that we want to get rental properties to possibly sell so that they can be brought back to family owner occupied. And the more housing that we need, we're obviously changing it so that there's another way of a type of a rental or for a reason for someone to gain an investment that's for them personally, but does not personally help our city itself. There's many things in the standards that say a lot of, it may not do this. It may not be a problem. It may not, will not be a regular week, regularly be very loud because it won't be used almost every day. There's no way you can tell that. So a lot of these are very empty when they say it won't be causing a problem for the area or a higher density of concentration, because that lot is very big and that would be very easy to have people have bigger parties in that long stretch of lot. I feel that we're not going along with our study about our home study that we put a lot of money into, and we're going the opposite direction. We need houses that can be sold again, and then we were supposed to be doing this as the redevelopment is to try to get these houses back out there on the market for homeowners. And if you have more and more people that are going to say, well, gee, I don't have renters in the summer, but I could use that instead. I can get tourist rooming in. Those of us in R3 are already surrounded by rentals. That's our break. We get a good break sometimes during that time of not having the over number of people. Some of the students stay and there might be only 1 or 2 that stay, but we don't have 6, 10 people coming in for a weekend or a week, whatever, to play. And so that's what this is. And it's going to definitely make a difference on our neighborhoods. And as the landlords are finding now, they're getting more and more concerned about not having rentals. The properties aren't becoming rental. Well, wasn't that what we were hoping by adding new rentals, that this would be, the domino effect would be that more places would then decide to sell, and then we'd have the opportunity to put in place some of the redevelopment conditions that we were looking at to help people buy these properties and redo them. So I think that it bothers me to see this going that direction, and I don't think anybody really thought of it that way, but it has a huge concern because there will be empty rental properties, and there will be a lot more people that will try to do it in this way. Thank you.
Thank you, Alder Nabel. Anyone else wishing to speak in the open or the public hearing? Public hearing remains open.
John Morrow, District 11. If I remember, part of the concern that we had was that we would have landlords that would be on site to help work through any issues. And the last one that we had, they did have a person that lived in Stevens Point that would deal with any issues that the house had. And here, I don't see anywhere that the owner has any maintenance or anyone that's on site or in the area that would be able to handle anything if any issues did arise. I'm not sure if I missed that or not.
Alder, as a point of clarification, the resident or the applicant lives at 1111 Minnesota Avenue. In Point.
I live in, oh yeah, you're right, because it's in Texas. Okay, sorry.
That's quite all right. Anything to add? Alder Morrow?
I'm all done.
Thank you. Public hearing remains open. Anyone else wishing to speak on the public hearing? And for the third time, the public hearing remains open.
Am I able to speak one more time?
Alder, you've already spoken on the public hearing. Is this something that you feel is critical?
If there was something more that I could add or not.
Okay. If you have something new, please add it.
New. I think it's very important that we listen to the person that wrote in that has her property right north of this address, that has given us information that the police have been called a few times already. And we could look into that further if we are given more time. And so to make a decision on this now without them having a license either, I feel that we're jumping ahead again on approving something, and it would be a mistake if we're not looking at what the fallout can be for this for many, many areas and maybe many neighborhoods. Thank you.
Thank you, Alder. Anyone else on the public hearing? The public hearing remains open. And for the third time, the public hearing remains open. Excuse me. That being said, seeing no one else wishing to speak, I will declare the public hearing closed. And before I bring it back to the commissioners, Director Karnowski, I know that you had taken a look at some of those written comments ahead of time because they came through your office, or at least I assume you did. Did you happen to notice if there were any police reports filed against that particular property, 133 2nd Street?
Mayor, I do apologize. I have not been able to do that due diligence to determine whether or not there's been any police reports filed against that specific property.
Okay. And we don't have any members of the police department here. I know they've been relatively busy. City Attorney Beveridge, I see you're connected. I'm wondering if you could speak a little bit in regards to the appropriateness of potentially postponing this, and whether that would be something we could do, or if we should just make a decision this evening, or if we could wait till next month.
After hearing all the comments, in fact, that's the only issue that I've been looking at here as we speak. I think I would really caution against postponing action on a person's zoning application, which is essentially what this is, solely on the basis of, oh, well, we're looking at changing the zoning code. That doesn't really speak to any of the standards that would have to be evaluated on the basis of this application, but rather saying, we're just going to ignore what the code says right now, despite the fact you've submitted on its face complete application, because we're thinking about changing the law in the future. I'm not sure I'd be real comfortable with proceeding in that sort of way. I think that it could be viewed as being sort of a de facto kind of moratorium on something that's being created absent any sort of actual any sort of actual legislative action by the body. So if there's a genuine desire to get further information about this particular application and whether it meets the standards, that's quite a different matter entirely. But delaying just in order to afford a chance to change the code itself, I think would be inappropriate.
And City Attorney, another question for you, because I believe that based on the allegations made of police reports being filed and us not having the ability to prove the validity of those police reports now, that waiting for that could be in order. However, if we're looking at changing the tourist rooming house ordinance in the next 2 weeks, is that appropriate?
Well, I can certainly look into this question, but I think really the question you'd be getting at there is, does this application have to be considered in light of what is on the books at the time the application is filed? My suspicion is the answer is yes. So the evaluation of this particular application might be independent of whether or not the ordinance is changed here in the future, even if it's changed in the relatively near future. But that's certainly something that I can research and report back on at a later time.
Thank you. I appreciate that. Commissioners, what are your thoughts or wishes? You can just unmute and jump right in if you want.
Mr. Mayor,
Commissioner Cooper, yes.
we did with that last one, was it last month? We did question the PD and we got that information.
Mhm.
So I think that would be appropriate in this case. But I agree with the city attorney that I think if this goes, something happens tonight with the code, I think we have to consider this one as the date it was applied.
Submitted, yeah.
Okay.
Yeah, I'm would like to know something more on the police bit of this.
Okay, that's
And I
Commissioner
think I
Haynes.
also have a question for Ryan on the license. Is that for the tourist rooming house or is that for something else?
So there is a license that the state issues. The county is the one who actually issues the state license, being that extension of the state. It is not in our current code required that the applicant get a license prior to submitting for a conditional use permit. They would have to, in order for them to operate at all, they would have to get the license and prove that license was obtained through the county to my office. And so the concern about, well, they haven't gotten a license yet. Well, if you look at the structure and how you do things, the first step you should do in this specific scenario, because our code doesn't call for anything else, is get the conditional use permit, then go through, make sure you meet the conditions. One of those conditions being that you need the state permit. And so, the applicant, if they don't get this conditional use permit, don't have to pursue the state license. So really no concern there from staff, because as part of the conditions, again, they're going to have to obtain the state permit.
Okay, anything else, Commissioner Haynes?
I'm just wondering, so were they running this through Airbnb, a tourist rooming house? And they
Not that I'm aware of. No, they've been, according to the application, they've been operating it as either renting both units to families or one unit to family, one unit to student rental. As far as my research has proven that they've not rented this out as this specific property out as an Airbnb. The applicant did make mention that they've done it previously. I don't know if that testimony actually called for saying specifically this property on 2nd Street was utilized for Airbnb. There might have been other properties that they've rented out that the city was unaware of.
Okay.
Okay, any other comments from the commissioners?
Yeah, this is Pete. Can you hear me?
I can, yes.
All right. Regarding the police calls, that's something that could be verified later on, but I don't know that it would be fair to the applicant to deny it. I don't see a date on the application or a signature for that matter, but I see a receipt here March 5th. And that suggested that there was time to consult the police department. And if it wasn't, the applicant could say, well, you haven't found anything, you haven't checked. I'm up for review. I don't see that as an issue for postponing the consideration. I also don't think that there are other reasons, but specifically potential changing in ordinances, that should delay it. I do think that if we go forward with this, I'd like to offer an amendment similar to the previous one, that it would be reviewed again in 12 months to address, again, this is the first time and there are concerns out there. And even, we may not be justified in denying it now, but I think we're justified in checking on it later on. And we can revisit those minutes to see just what that amendment was. So those are my initial thoughts. I don't see we have a good reason to deny it.
Okay, thank you. Any other comments from the commissioners? Or a motion?
Actually, could I ask Andrew Beveridge to talk about the denying a conditional use and the reasonably new law that has been put in place about conditional uses?
City attorney?
So generally, the way I would describe that is similar to what I would say anytime you've got a quasi-judicial type situation, which is that you need to have the record reflect that the decision, whatever it is, was made based on a consideration of the appropriate standards and an application of evidence to those, or I should say, applying those standards to evidence that's in the record. Now, most of the time, the Plan Commission is going along with the recommendation made by staff, in which case the findings on the record are quite clear because they're laid out in the staff report, one by one, going through each of the standards, talking about what their view of the facts is, and then arriving at a conclusion. When the Plan Commission wants to do something other than what the staff has recommended, that's when it just becomes a little more complicated to make the motion, because what you need to be able to do is say, okay, I'm pointing to these one or more factors from the ordinance and saying, I disagree with the staff report on the basis of X, Y, and Z. So essentially it would be, to pick out those specific factors and say, here's why, based on the evidence that I've heard and what I've seen in the report, I disagree with that, and make sure that it's clear in the record. And that way it affords, in the event that the action is challenged and it goes to court, it provides the court with a basis for the reasoning underlying the action.
Okay, and then how about city council? How does that apply to city council?
Essentially, the same rules would apply. So if the council, for instance, was going to disagree with the Plan Commission, I would provide the exact same advice to a council member who's seeking to make a motion to that effect. You just need to make the reasoning clear and explain which elements of the record that's before you support the motion that's being made.
Anything else, Commissioner? Okay.
Oh, sorry. I just, when I was listening to the city attorney there, I guess the thing I was hung up on there a little bit was the word, again, evidence, and wondering again if if we do have the evidence of police, activity or reports that could affect some of the standards of review, I guess, that are in there. So, I agree with Pete when mentioning that, with what we have and the findings we have, and approving it based on those would be okay. But I don't know if we can put a condition in the motion of such a thing as pending a police report or information from the police, I guess.
Okay. So
is there a way to do a motion of approving it as the conditions are pending a police report or something? I don't know.
No, I don't think that's appropriate. But what we could do, and Logan, correct me if I'm wrong, we could motion to postpone this and ask Director Karnowski to obtain any police reports for that property. And then we could use that to make the decision next month in regards to the condition, the standard of review, specifically number 1, as it relates to the safety of the neighborhood.
But one other thing before the city, just to clarification as well, to after that postponing it, still applying the ordinance as it was on on April 6th.
Right, and that's my belief. We would have to use base the approval on how the ordinance was worded today, or when the application was submitted, which March 5th, I think, was the date. But we would be able to use any evidence provided by the police department as we consider those standards of review. Logan, is that about right?
I don't see any reason why there couldn't be a delay here, as long as, a reasonable length postponement in order to seek further information that is relevant to the standards under the code. Just one quick note here. This touches on something I'd mentioned earlier with regards to what version of an ordinance has to be considered if the ordinance were to change. There is a case here. It's called Weber versus Town of Saukville. It says, unless the zoning ordinance provides otherwise, a court should measure the sufficiency of conditional use application at the time that notice of the final public hearing is first given. So essentially, you can't change the ordinance and then say you don't meet the standard. So I do think, though, based upon the comments that were received, I believe it was one of the written ones that the mayor mentioned with regards to some of these loud parties or people trespassing across a neighbor's property. I think there could be a reasonable length postponement to seek further information about that.
And City Attorney, would you consider a reasonable length the next month's meeting, which would be May?
Yeah, I don't think that you could make a real strong case that would be unreasonable. That
Okay.
is the next regular meeting. So.
Okay.
Mayor, if this is Director Karnowski, let me just state as well that we will not have another public hearing then in May if this is postponed, that the public hearing requirement of the conditional use permit has been satisfied. And so this would just be something to reconsider just from the Plan Commission's perspective, that there's no need for another public hearing.
I would concur.
This is Andrew Beveridge. Yeah, I think that would be okay to think of it that way. So essentially what you would have then is that the record would be the documents that were before the board today, or excuse me, the commission today, the comments that were put forward today, and then the last thing would be whatever information is received in terms of just documents essentially from the police department as to whether there's been any sort of calls for activity there.
Okay. Commissioners, do you have a motion?
Is there one more comment that I could make that I feel like you've missed that I've said about some of the standards? That I feel that there are standards that are not being met.
Alder Nabel, you've had your chance to make those comments during the public
They
hearing.
were ignored.
Commissioners, what are your wishes?
Mayor, I would move to postpone the determination on this conditional use permit until next month's Plan Commission meeting in order to allow staff to have time to further investigate complaints against the property.
Okay, as part of that, we would ask Director Karnowski to get calls for service from the police department going back a certain period of time. Should we say a year?
Sounds good.
Okay, so the motion is to postpone action on this till the May Plan Commission meeting and ask Director Karnowski to get police report information for that particular property going back 1 year. Do we have a second?
I'll second. Ms.
That
Pete.
was Commissioner Arnson, second by Commissioner Arnson. Any discussion on the motion?
I just have a question. I don't know if it's directly about the motion, but is this something that we should establish? Is there a checklist that you go through when we get an application and is calling the police department, notifying the neighbors, public health, et cetera? Is that part of the review process?
Well, I don't believe that checking on any police reports on the property have been. Some conditional uses or conditional use permits have no bearing, I guess, on the police department reports, but we could certainly add that to the ones that are relevant. And I'll ask Director Karnowski to do that for future conditional use permit requirements or requests. that have a bearing on the police reports or that would potentially be affected by police reports.
All right, just makes sense because the same issue came up last time, it seems, and could continue to do so.
Sure. For example, putting up a shed might require a conditional use, but really police reports probably wouldn't have a whole lot to do with our decision on that. So
Agreed.
the ones that are relevant, I will ask Director Kanowski to get police calls, if any. Okay, any other comments by the commissioners? The motion is to postpone action and ask Director Kanowski to get us police report information for that property. If you are in favor of the motion, vote yes or aye. Aye.
Aye.
I
If you are opposed, say nay. And the motion is approved. Motion to postpone is approved. So we will have this on the agenda for next month. Next item is item number 4, discussion only on an ordinance amendment to the revised municipal code of the city of Stevens Point, chapter 23, the zoning code, specifically sections 2302, sub 1, sub F, sub 4, and section 2302, sub 1, sub G, sub 4, relating to minimum lot density for 2-unit dwellings within the R4 and R5 zoning districts. Commissioners, page 75 of your packet. Director Kanowski, you have the floor.
Okay, thank you, Mayor. So staff has been working with a developer who is seeking to construct a number of 2-family dwelling units on a specific property here in the city. That property is zoned R4, which is our multiple family 1 residential. So upon review of the plan and the city zoning code, we found that the properties that are zoned R4 and R5 were less dense for 2-family development than the city's R3 single and 2-family. So as a comparison, the city's R3 zoning allows for 2-family buildings to be constructed on 10,000 square foot lots. In the R4 and R5 zoning district, we allow 1 2-family dwelling per 12,000 square feet of lot. And I'll provide just a visual for some who may not be able to mentally comprehend something like that in just the policy format. So, you know, our zoning code is written in such a way that the R4 and R5 zoning districts are typically intended to be at or more dense than the R3, R2, and then the low density residential zoning districts. But in this case, I think it was just a simple oversight. This last summer in June 2019, we did reduce the square footage in the R3 from, I believe it was 12,000 square feet to 10,000 square feet. So just for those who need a visual, on the left-hand side of the screen is the current R3 zoning code at 10,000 square feet per 2-family. The property size, which is the green square, is 150,000 square feet. Under the current code in R3, the developer would be able to construct 15 2-family, and that would be allowed in that zoning. Now, if you get into our more dense zoning districts of the R4 and R5, at the 12,000 square feet per 2-family requirement, the same 150,000 square feet divided by the 12,000 square feet would allow 2.5 2-family. Our code states that it has to be rounded down. And so you'd only get 12 2-family as opposed to the 15. So if you look at the same lot, the same different zoning and different regulations, you can see that what is typically 1 and 2 family is supposed to be less dense, is actually more dense than the R4 and R5 zoning within our zoning code. Given that, we need to, staff believes that we need to amend our zoning code because we think it's working against itself. Higher density uses should be in the R4 and R5 zoning districts. And so we've put together a proposed amendment that would align the density of the R4 and R5 to be the same as the R3. So it's across the board 10,000 square feet for 2-family dwelling units. The Plan Commission could also consider allowing an even denser development, say, for example, 8,000 square feet per 2-family dwelling in the R4 and R5 districts. Again, no formal actions required to be taken. If there's an appetite from the Plan Commission to go ahead and do something with this, staff would then prepare the public hearing notice and draft the ordinance and bring it back to the May meeting. And so with that, I would ask if there's any questions that I can answer. Here's just in your packet, you can see itself. This would be the R4. We would be striking as proposed the 12,000 for 2-unit make it 10,000, and then the R5, the same thing. We'd be striking the 12,000, make it 10,000 square feet. So.
Okay. I'll just make a comment initially that it certainly doesn't make sense that we have lower zoning units less restrictive, or more restrictive rather, more restrictive than the higher zoning units. As the numbers go down, the restrictions should be a little more defined and probably a little more strict. So I think it makes sense that we look at the ordinance amendment to reduce the density for R4 and R5 and at least align it with the R3 zoning. With that, I would open up the floor to any other comments from alders or commissioners or public.
Yeah, I agree. I
Oh.
think this is Anna. Sorry. I
Go
do
ahead.
think that we need to fix the zoning ordinance. It does not make sense. R4 and R5 should have at least the same density, if not denser.
Okay, thank you. Alder Nabel?
Yes, thank you. Alder Nabel, District 3. I have no problem with R4 and R5 districts going to that density, but I am surprised when I question about R3 that the possibility that the conditional use could be used where they could add more than a two-family house on a property where we're considered a single and two-family zone. All of a sudden sounds like could become a fourplex or whatever, and with more rentals upon it. So I'm concerned that maybe R3 should be changed up higher so that that's not going to be, it went for, I don't know when that happened for 10,000 square across the board, but I also don't remember there ever being a conditional use for them to be able to put more than a duplex on a lot. That's the reason way back when that the board decided to change to a certain square footage to keep houses that were on these smaller lots from becoming duplexed. And now it seems like it could be going against us even more if now we're going to be just like R4 and R5. I understand R4 and R5 are different and they have multiple units. I would like it to stay that R3 is not going to be a multiple unit. It could still say as townhouses or duplexes, but I wouldn't want them to be, the property shouldn't be so dense that they can stick 2 more extra units on or 4 more extra units onto one lot.
Okay, thank you, Alder Nabel. I would ask that you contact Director Karnowski in regards to your R3 zoning concerns, and we can look at that one in the future as well. Any other comments?
Commissioner Rice.
Yes, sir.
Director Karnowski or city staff, just wondering if you have kind of a minimum density recommendation for R4 and R5, if we would be interested in pursuing something even more dense, and what are the options for developers who would be looking for something more dense than what would be allowed under the current ordinance?
Sure. Yeah. So, I think that 10,000 square feet would be appropriate. Even lower, I wouldn't go much lower than 8,000 square feet. I mean, you're really starting to push the envelope there when you think about the impervious surface. You think about how large some of these duplexes could get on some of these smaller lots. But if you're looking at some decent infill development, having a 2-family on an 8,000 square foot lot may make sense. Again, if you look at the return from a 2-family as opposed to a single family on a lot, it's something that, the commission may want to consider as well. Tax return, I should say. So there's some money coming in. In terms of trying to do a denser development than what's allowed within the zoning code, we do have the planned development districts, planned unit developments that, it's a special zoning overlay that can be formed to fit the request of the developer. And it has a number of additional standards that have to be met in order to qualify for a planned development district or planned unit development. And so we do have that. Just real quick relating to Alder Nabel's comments earlier, within our zoning code, in order to have more than one principal structure, on a property, you do have to get a conditional use permit. So it's not, and within that conditional use permit, they would still have to meet the minimum zoning underneath that property. So if let's say that the developer wanted to put 2 duplexes, so 4 total units on a 20,000 square foot lot, they would be able to do that as long as they get a conditional use permit. So that's just something to think about as well. But I would say, yeah, 8,000 is probably the bare minimum I would go in the R4 and R5 zoning districts. I think I'm more comfortable above that at the 10,000 square foot.
Okay, thank you.
Okay, any other comments?
I have one, actually. I tend to agree with Alder Nabel. I wonder if the R3 should be a little less dense just to provide a transition area between the less dense to the more dense. Just a thought.
Just, Mayor, this is Director Karnowski. It should be noted that the R3 zoning, I mean, the majority of lots in the city, I would say, are R3, and that is what I would call the more traditional neighborhoods in the city. So the core kind of reaching a little bit further out. And so you already have, it serves as a quasi-transitional district from the business core, the historic downtown, out into our more suburban style developments. That R3 really serves as part of that transition. And so that's just something to remind ourselves that it is a higher density use just because of the traditional development patterns of the city, and that you can have 1 and 2 family on lots within the R3 district. That is a permitted use.
Okay. Any other comments? Nothing in the chat room. So, Director, I think generally, because this is a discussion only, I think generally we would be interested in looking at your recommendations in regards to R4 and R5. And Alder Nabel is going to contact you along with anyone else who has comments in regards to the size, minimum size for R3. And if we need to, we'll consider that at some point in the near future too.
Mayor, can I just ask for clarification? Is the Plan Commission seeking the 10,000 square foot in the R4 and R5, or would you like something more dense and with the 8,000 square foot, for example?
Commissioners?
This is Commissioner Rice. Yeah, I'm just looking at the zoning map of the city, and there's a lot of relatively dense neighborhoods with relatively small lots, and so the 10,000 square foot is a minimum square foot for permitted use, correct?
Correct. And that would be for 2 units. So if you break it down further, each unit would have to have 5,000 square feet of lot.
Right. And so, on the north side, even around the campus area, I mean, a lot of those city lots are, 50 feet by 100 feet, maybe a little more. I mean, are 6, 7, maybe 8,000 square foot lots. I mean, would be a relatively big lot in that neighborhood. There's likely, I assume, non-conforming duplexes in a lot of those neighborhoods already. Are we, I guess, to Alder Nabel's point, maybe we are trying to limit people's ability to kind of convert single family homes into duplexes if we get, this square footage number down to a certain point. But are we limiting people's options, I guess, in terms of, what they can build in a zoning district that is intended for, potentially 2 family homes?
That's a really good point, Commissioner Rice. We do, I haven't gotten a lot of requests, but I have in my short tenure with the city of people asking, can I convert a single family home into a duplex? And kind of the thing that I hang my hat on is, well, you don't have enough lot size to do that. So the answer is no. We did have a fire on Smith Street, and that was a duplex. And now the property are saying, well, can I rebuild it as a duplex? And we're having a hard time saying, well, yeah, you can, because the underlying zoning requires 10,000 square feet, and he's got about 6,000 square feet. And so when you look at it, and these are non-conforming lots, the purpose of non-conforming is that someday they will become conforming to the zoning code. And so, just remember that the lower we get, the higher likelihood that you're going to have some houses that could be transformed into two-family if they meet the minimum lot size requirements.
Right. That makes sense to me. This is Commissioner Rice. And I guess just to put this to the rest of the commission as well, I mean, is not the goal on some level to increase density, especially in the urban core of the city? And would that not be somewhat beneficial on some level to allow some conversion or, as we look at potential future infill projects, to make it easier for people to do more dense units? Or I guess obviously there is, of course, the alternative of using, plan unit developments for situations where, maybe we would be looking to do something that wouldn't ordinarily be allowed.
Yeah, so I should clarify too, we're not looking to change the R3 zoning. This is the R4 and R5. And if you look at the zoning map, a lot of the R4 and R5 is actually in some of our more suburban style developments. So I think about, our apartment units maybe on Stanley Street. Those are the R4 and R5 areas. And so we would just be making those more dense. Now, we could have a discussion on making R3 more dense if that's something that the commission would want to do as well.
Okay. Any other comments from the commissioners?
I'm supportive of the changes to R4 and R5 to 10,000, maybe even down to 8 or 9. I need to look at the zoning map myself though.
Okay.
But I don't want to open up a can of worms right now with R3. I don't know what our time frame is. We had talked about redoing the zoning code, and that project is who knows where. But yeah, I prefer not to mess with our current zoning code unless we are not going to revise completely.
Okay, well, that project isn't dead, but it certainly has become a little bit stagnant. We're working on rejuvenating that.
Priority.
No. So generally, I think, Director Karnowski, that the commission is okay with the 10,000 or potentially even 8,000 square feet in the R4, R5. And we can consider changes to the R3 zoning after we have some further discussion on that. Right now, tonight, we're talking about R4 and R5. That was the agenda item. So I'd like you to, I think generally we want you to move forward with providing us with a recommendation to be considered at next month's meeting.
Sure. Mayor, on the screen, I hope everyone can see it. I hope I did it right. But you can see kind of this.
No.
You can see my map. No.
Nope, we can't see your zone. You'll have to go back into the share and then share that particular application.
We'll see if this works. How's that?
There you go.
Okay, so you can see, if you can see my mouse, I do apologize, that this is the downtown near the Clark Street Bridge. North of town, that's all R3, north of downtown. And then if you go south and east of downtown, you also have the R3. Now, if you look at
So
where
we're talking about, Director, we're talking about the yellowish color.
Correct. Yep, the darker yellow. The lighter yellow is our R2 zoning. But if you look down here where the townhouses are behind off of Riverview Drive, that's an R4 zoning district, for example. And then, of course, off of Stanley Street, we do have some higher density adjacent. I think the Village Apartments are back there. And then we do have the Doolittle Drive Apartments. That's also R4 zoning. If you look at the pinkish, you can see where we have some denser apartment buildings, kind of, I guess, not necessarily within a transitional district, but right up against R2 and R3 zoning itself. So I just want to throw that out there for those who are curious as to the various zoning districts in the city.
Thank you very much, Director. We appreciate that. Okay, with seeing no additional comments, I think we can move along to the next item, which is item number 5.
Okay.
And that is discussion only in regards to the revised municipal code, chapter 23, relating to the operation of non-owner occupied tourist rooming houses in a residential zoning district. Commissioners, page 79 of your packet.
I hope you can see my PowerPoint. Is that accurate?
Yes,
Okay.
your PowerPoint is back up.
Perfect. So as alluded to earlier in this meeting, the City Council is requesting that the Plan Commission consider an amendment to the zoning code as it relates to the use of non-owner occupied tourist rooming houses within our residential zoning districts. Essentially, in conversation with some alders, they would like to see non-owner occupied tourist rooming houses prohibited within all residential zoning districts. I think that in conversations with these alders that retaining non-owner occupied within the business district would be okay. The current codes allows owner occupied tourist rooming houses in residential zoning districts as a permitted use. However, non-owner occupied tourist rooming houses require a conditional use permit. That was amended in June of 2019. We being city staff recommended the change to allow non-owner occupied tourist rooming houses as a conditional use in all residential zoning districts based on these 6 standards, and that was discussed at length in June of 2019. I think in May and June of 2019. And so up on the screen is what was included in that memo, and that's also included in the agenda packet. Upon further review, and I think after doing a few of these, several concerns have been identified. That being non-owner occupied tourist rooming houses, the use itself are more likely to be prone to parties and neighborhood disruptions. This is because no one's on patrol, no one's at the site to patrol the guests, if you will. There's a concern that the use will cause destabilization or continue the suppression of non-owner occupied housing in neighborhoods within our community. And that the use will encourage more vehicles traffic within neighborhoods, especially for those who are able to rent out their entire homes as opposed to a bedroom or 2 within a house. And so the question that staff has kind of been grappling with is, are we working against our community's collective goal of stabilizing our neighborhoods, reducing the number of rentals within our neighborhoods if we continue to allow this? Is the city promoting this use at the expense of our neighborhood stability? So a question is going to come up that, if we were to amend the code to state that non-owner occupied is no longer permitted at all within the residential zoning districts, how would that work with our existing conditional use permit grantees? 3 examples on the bottom, one being the Ridge House, which I think we're all overly familiar with now, the Claflin House on the corner of Main and Division, and then I don't think that this house is a specific name, but on the far left, that's a house that's on Main Street that operates with a conditional use permit. So if the commission were to amend the zoning code to no longer allow the non-owner occupied tourist rooming house within residential districts, these existing properties would become legal non-conforming or just non-conforming uses because they are all zoned either R2 or R3 single family or 2 family residential. And the only way to lose that grandfathered status so they could continue to legally operate would be if they would discontinue the use for a period of more than 12 months or it would restrain them from expanding. So I know there are some long-term plans with the Claflin House to do some additional housing units just west of the property. That would not be allowed under the existing conditional use permit, that we would simply say, you can't do this anymore. You have to keep the existing use within the existing footprint of the property. So let's say the Sherrills who operate the Claflin House wanted to build another house adjacent to this one and operate as a tourist rooming house. That would be prohibited because of the amendment in the zoning code. So just think about some of these things as we go through this conversation. The Plan Commission can take no action tonight, but we're seeking some conversation in some direction. Is this something that the City Plan Commission wants to amend? Again, the members of the council have asked for this to be reviewed. So you really have three options. You can keep the zoning ordinance as it's currently written, where non-owner occupied tourist rooming houses would continue to be a conditional use permit in all residential zoning districts, and owner occupied tourist rooming houses would be permitted in all residential zoning districts. You could amend the zoning code to reduce the size and scope of non-owner occupied tourist rooming houses within the residential zoning districts. Let's say that they would only be permitted in, let's say, the R4, R5, well, R3, R4, and R5, for example. It doesn't have to be that way. So instead of being in the down zoning, the R2 and the RLD, which is our low density, more suburban style, we wouldn't allow it, but in higher density, we would allow it, for example. Again, when you talk about the R3 district, it's close to a lot of the amenities that I think tourists are looking for. The third option would be amend the code to discontinue any new non-owner occupied housing in any residential district. This is what the city of Madison does as well. They've been grappling with the concerns and issues of tourist rooming houses for a number of years now, and they've recently amended their code. This would require that any tourist rooming house be owner occupied. Please note that the Madison ordinance does not require that the property owner is present at the time of the rental, that they could, for up to 30 days, be in Arizona and rent their house out, things of that nature. So, but it's up to 30 days. There's a maximum. We can get into the draft ordinance that's included in your packet, but I think what I'm seeking right now is just some general discussion, and we can get into the draft ordinance as the conversation goes on.
Okay. Alder Nabel, you had submitted some written comments. Do you want me to read those, or are you going to speak on your own behalf?
Oh, she's on mute.
Yep. Hang on. You're on mute, Alderperson. Let me try and unmute you here. I think you're going to have to unmute yourself. I can't do it.
Okay, there.
There you go.
I'd love to have you just read it.
Okay. I will read Alder Nabel's comments. And stand by. Hello, City Plan Commissioners. Thank you in advance for taking the time to read my email. I believe that with the facts and recommendations from our 2017 MSA's housing study, along with concerns voiced by staff in March 2019, I am able to provide several compelling reasons why the tourist rooming house ordinance is being brought forward with the request for amendment and your approval. However, I would first like to address why many of the council members approved the tourist rooming house ordinance for conditional uses in zones R3 and R2. The objective, we thought, was to provide owner-occupied homeowners the ability to stay in place longer, an opportunity to earn extra income, and the affordability to improve their properties and thus improve our city neighborhoods. A memo from the Plan staff to the Plan Commission on March 27, 2019, voiced their concerns about the possible impacts of tourist rooming houses, what they could have on R3 and other lower residential zoned neighborhoods. They shared their thoughts that tourist rooming houses were also occupied by the owner would have a lower impact on its neighborhood than those utilized solely as a tourist rooming house. Currently, tourist rooming houses have conditional use in both R3 and R2 zoning districts. This allows an individual to get a permit for their property or home, whether or not they reside on the property or even within the state. Tourist rooming houses are stated to be used as personal investment opportunity and not as the intended opportunity to assist with the permanent city residents, our city or neighborhoods. As presently written, tourist rooming houses do not follow our MSA Stevens Point Housing Studies plan and its findings and recommendations. Specifically, home ownership is still a very common aspiration, even among millennials. The city's housing stock is disproportionately weighted towards rental units. There are approximately 49% of owner-occupied housing stock and 51% of the renter-occupied housing stock. Stakeholders have noted that the supply of single-family homes on the market is limited. Improve the supply of available quality single-family homes within the city. Improve the perceptions about the quality of city's neighborhoods. Increase the inventory of homes available under $300,000 into the housing supply. Goes on to say the use of tourist rooming houses as it currently stands does not add to our city's much needed housing market. It will only increase the number of individuals who will begin prospering on the back of our city residents while they may reside elsewhere. Bottom line, the tourist rooming houses conditional use permit does not represent with the recommendations we have received from our most recent housing study. Thank you, Alder Cindy Nabel. With that, I'll open up the floor to anyone else who wishes to speak on the topic.
This is Anna.
Lori Jennings.
I don't have Anyway, I like the idea of reducing the size and scope. I do like the idea of at least maybe a conditional use with non-owner occupied. I personally know I have rented houses in various places and I would not want the owner there. So I was thinking about our traditional neighborhood overlay district, and I was wondering if we could either create an overlay district for tourist rooming houses, or if it could be sort of part of that traditional neighborhood overlay area, right? It's a very specific area around the downtown. And it seems like that's where we might want tourist rooming houses to be so people could take advantage of our lovely downtown. So just an idea to throw out.
Okay, thank you. Alder Jennings, I know you want to speak.
Yes, thank you. I want to thank Director Kanowski for working on this and responding to my concerns and the concerns of other alders. I really hope the commission will take inspiration from Madison, which has worked for a very long time and struggled for a very long time with this. They have come down to the position that the property needs to be the primary resident of the individual, even if they are not there at the time of the renting. The major problem we have, and we've already seen it several months in a row now on all these applications, is the issue is centers on non-owner occupied. So I hope you will consider number 3 and basically follow what Director Kanowski has outlined in terms of this being a primary resident. I think that is the most important thing and what we have been struggling with.
Thank you. Any other comments?
This is Andrew Beveridge. One thing I would throw out is that if we are going to have an ordinance that's hinging on whether or not something is owner occupied, we need to have a clear and working definition of what it means to be owner occupied.
I would concur on that as well. So Director Karnowski, let me ask you this. The zoning, for example, for the Claflin House, should this be changed, would, let's say it's option 3 where it must be owner occupied, would this fall under the new ordinance at any point, or because it's already been approved, is it grandfathered in effectively on that approval until the conditions change?
Right. So the Claflin House being a good example would be grandfathered in. It would become a non-conforming use because at the time of the zoning code, it was approved through conditional use. And as long as they continue to operate the Claflin House for on or off for 12 months, if they go 12 months one day, they lose that non-conforming use status and could not be reverted or reused as a tourist rooming house. That again, it also states that if the Sherrills so wish to construct townhouses on Main Street for the purposes of a tourist rooming house that's not owner occupied, under this proposed zoning code, it would not be permitted, that they would have to live in the house in order to operate it or it would have to be their primary residence based on, as Attorney Beveridge discussed earlier, some standard, whether that standard be, this is where you're registered to vote. That's always a pretty decent standard of, hey, I live here because I'm registered to vote at this address. So just know that there are some other concerns that come along with just saying, well, we don't want it at all, because the Claflin House is zoned R3, which is our 1 and 2 family residential. Does that answer your question?
I think it does. I'm just looking for examples to try and put it into what we have going on right now. Another question would be, in an example, let's say the Ridge Road Airbnb that was recently approved. The applicant said, or at least claimed at one point, that was his primary residence, but he winters in, I believe it was Arizona. Going back to what Attorney Beveridge said, he would then have to reaffirm that owner-occupied status in some way. I don't know how we would necessarily do that, though.
Yeah, so to address that specifically in the draft ordinance that's in front of you, where is it in here? Non-owner-occupied tourist rooming houses. I'm sorry, owner-occupied tourist rooming houses could continue to operate without the owner there, but for no more than 30 days. So essentially 30 total days in a calendar year, for example. You could rent your house out and not be present. The other days outside of the 30 days, you would have to be present when you operate it. If that makes sense. So,
okay. Do we know how Madison enforces that?
That's my question.
Yeah, that's a great question, and I'm not sure how they enforce it.
Okay, maybe we can just have you do some research on that, because we're not going to make a decision on this tonight. But Alder Jennings, you had another comment?
Yes, in talking with a alder in Madison regarding the Claflin House, and I think we all hugely support and appreciative of what the Sherrills have done. And I would personally support any future projects that they do. That corridor could be fantastic with the work that they appear to be planning. So one question that came forward was, why wasn't that approved as an inn rather than an Airbnb? So I wonder if we're just being too narrow in how these places get defined, so that is there a way to sort of approve their projects through other means? Thank you.
So I could address the inn question. So inns are typically bed and breakfast facilities, and in bed and breakfast facilities, the state requires that the owner lives on premise. And typically in an inn situation, there's some type of food served. So there is some commercial kitchen component there as well. So just, the bed and breakfast is a good example, but just know that the owner does live on site. And that's how the state regulates that.
Okay. Any other comments?
Well, I just want to get back to mine. So if Ryan, if you could think about an overlay zone, like how would that possibly work, right? If we were to define a specific area that's appropriate for tourist rooming houses.
Yeah.
Rather than it being everywhere.
Yeah, your traditional neighborhood overlay, and I can pull the map up, is essentially a lot of the R3 and R4 zoning districts that are surrounding the downtown. Think of your traditional development pattern. That's where and that could be included as part of it. I think if you look at the amenities that visitors and tourists are looking for, they're more focused downtown than they are anywhere else in the city. So maybe that could be a discussion as well. Or I'd hate to do it, but you could also look at doing just a completely new overlay that identifies specific areas for a tourist rooming house that's close to the core.
Okay, any other questions or comments?
I have a comment regarding the last thing that Director Karnowski said. We've got the Portage County Youth on Ice hockey rink out here in the soccer fields. And, you know, there might be a tournament out here, and I live very close to there and have a couple of extra rooms. So I wouldn't like to be neglected as an owner-occupied tourist or an Airbnb should somebody want to be able to walk down to the soccer field for their kids' soccer camp for a week. So if we start to do overlays, don't forget some of us on the fringes or around areas that would be a tourist draw.
Okay, good point. Any other comments?
Commissioner Rice. Yeah, and just the discussion and hearing what other comments are from last month as well as tonight. It's just seems like a lot of the concerns from neighbors of these potential properties and from the alders as well are about regulations that there are already city ordinances about. I mean, we're talking about noise violations or occupying a home in a density kind of out of scope or out of a safe occupancy, potential trespassing on neighboring properties, and parking issues, all of which are, enforceable violations. We're talking about bad behavior, not necessarily, that the letting people rent a house is wrong, but it seems to me that, like a full sweep of not allowing these rooming houses, even in situations where the owner, it's not the primary resident, it does take away, what could be really advantageous for a lot of people. And I agree that there are issues that we'd have to navigate, but I guess I would be more in line with Director Karnowski's idea of trying to limit the scope of maybe what properties are allowed or try to rein in the number of occupants or some additional rules to make sure that they are being operated appropriately and aren't causing detriment to the neighboring properties. But trying to limit it completely, I think, is unnecessary.
Thank you. Anyone else wishing to speak?
Yes, Mayor, this is Andrew Beveridge. Commissioner Rice's comments kind of touch on some overall thoughts I've had about this entire topic, which is part of the reason that we're encountering a little bit of uncertainty and difficulty, I think, is that we're trying to anticipate issues before they happen and taking educated guesses at what they might be. And that's hard, rather than just saying, what actual real impacts are we seeing once we have kind of a track record and some data to look at here. You got to remember that with regards to conditional use permits, at least, they contain provisions saying you have to do X, Y, and Z to not unreasonably interfere with the surrounding properties. And that takes the particular type of zoning into context there. So if it's in a residential area, it's, are you unreasonably interfering with use of the neighboring properties as residential properties? So if you end up having a situation where a place is licensed via conditional use and it is consistently having lots of noise or lots of impacts in terms of light or just commotion that are kind of undermining the character of the neighborhood, that is an enforceable situation, and up to and possibly even including withdrawal of the conditional use permit. So they are not zoning variances. Once you get a conditional use permit, it doesn't mean that you have it forever, barring some sort of court case or anything like that. They've got a lot more flexibility than that. So we should just keep that in mind, is that, there could be some wisdom in saying, let's see how these things play out for a while and then tailor our rules to clamp down on the actual negative effects that we're seeing.
Thank you. Very well put. Any other comments?
Yes, Cindy Nabel, District 3. Again, I want us to remember what we've seen in the past. There's already a history of record of housing that was supposed to be licensed to be more than 2 unrelated people, which had gone to parts where houses that had 5 bedrooms that were single family homes all of a sudden had 5, 6, 7 people living in them. And we were told by city, well, we can't prove it. So we have lost a lot in our neighborhoods just due to the fact that we set something up for it to be allowed. And I really think you got to think hard and fast on this. You already have a rental of 49% or 51% in this city. And our study, no one's remembering this, that we're supposed to be trying to sell some houses or to get houses that were rentals to get empty out so that we can sell them and get homes and have homes so we're not having to expand out further into the city for new roads and other things. There was a big study on this, and it was stated in this area specifically that they should not even allow if we did change the family, the description of what family is, that they shouldn't change it in this area where it's already been so overloaded. I think it's easy for anybody that doesn't have it right next to them to say, well, if there's something happened, you can call the police. You've not been around enough to know how many times that is maybe 10 minutes and gone, and the police can't get there before that for you to report it. And how many people quit reporting after a while because they're just disgusted. We need to protect the neighborhoods and not make this into a money maker for who? I mean, we say that we're trying to make our neighborhood, we're going to put all this money into our downtown and all this money into Division Court, the whole street, and all these things that are, how important is it because we have all these amenities that people want to live close to downtown. When we don't have houses they can even get into because they're either already rentals and they won't be able to buy them to redo them because they're so high priced. You're giving more opportunity to some of the landlords to not give up these houses. And I, for one, think that if you have an overlay over an area over in the area of downtown where the person did not have to be there, that might be an option. But I also think that you could still have it where if the owner occupied was there, like Alder Kneebone said, if you have so many days, then you can still rent out and be gone. Or you could stay there and rent out. So it's not giving you the opportunity. But our main reason for this whole thing in the beginning was to help homeowners to be able to afford, to be able to redo their houses that they mainly lived there, not just live there by paying taxes. And I just really am frustrated to see us going backwards because we've already seen what has happened since the late 70s of our neighborhoods and how they've deteriorated because of greed. And it will happen with this too. And I think we really need to be careful on this. It just can't be so many in all these areas. It is going to just keep the landlords happy. I'm sure they'll enjoy this. It gives them an opportunity to find a way to rent those places that they can't keep rented now, that we're adding on to new apartments. But now what that'll happen is that it'll just be the worst coming in here, and it'll be people that are here only not just for a school year, which I don't mind because you can get to know those people, but people that come in and go for a weekend are not going to give a rip about the neighborhood. And so I'm afraid we're really just I understand the Kaplan House, that would be grandfathered in, but we cannot just say because of that one place that this is why we should do this, to have it as owner occupied, not owner occupied. I think we're going the wrong direction, and you see it. Madison has done something about it because they've seen problems, and we're just going to ignore that.
Thank you very much. Alder Jennings, you had another comment?
Yes, to Commissioner Rice's comments. Excuse me, I certainly understand the logic of that comment and the rationale. However, I have lived for 10 years next to a student boarding house and have to do the continual dance of when am I going to call the police? When am I not going to call the police? How much noise do I put up with? What is the line? And it is not possible to expect the ordinances to be enforced when a person lives next to one of these houses. And basically, we're expanding, we have the unintended consequence of expanding what we already have with student housing more broadly under the guise of Airbnb by not refining our ordinance and looking to what other communities have done. Why do we have to reinvent the wheel here and wait and see what happens? There's plenty of communities, not only in the state, nationally and internationally, who have done this and figured out how to do it better. I ask you to figure out how to do it better now rather than waiting and frustrating lots of people, many of whom have already come forward and expressed their frustration. Thank you.
Thank you. Any other comments? Any other comments?
Yeah, let me chime in. This is Pete Arnson. Just wondering about the conditional use permit. I think I've heard it commented previously that once they're granted, they're tough to take back. And I guess I'm wondering just how difficult is it? How unusual is it? Is that process well defined at all? And kind of tailing along with that, if there are offenses with the property, who gets punished? Is it the owner that gets fined? Is it the occupants that get tossed in jail? How do these things work? I'm just not certain, so asking. Thanks.
City Attorney?
Well, unless there is a crime committed, there's likely not going to be any tossing in jail of anyone. But so it depends. I mean, you can have certain conduct or events or a pattern of conduct that constitutes a violation of the terms of the conditional use permit and therefore constitutes a violation of the zoning code. That would be potentially enforceable via a citation issued by the Community Development Department to the property owner. If there was just noise going on, it could result in a citation for the noise violation issued to the people who are at the property at the time. The same as if they were just a tenant, that sort of thing. If there were ongoing issues of that type, it could be addressed via the conditional use permit and the zoning code, or potentially even be addressed via the chronic nuisance program. Probably be more direct and simple to do it via the zoning mechanism. But so it's going to depend on what sort of conduct's going on. If there's a screaming loud fight happening and the police arrive, that could be disorderly conduct tickets issued to the persons involved at the property, that type of thing. But again, with a scenario like that, even though the tickets were issued to the people who are actually there, the fact that it happened and it caused this level of disturbance to the neighborhood would be relevant to the underlying conditional use permit, which involves the owner, obviously. So there's sort of an interplay there.
Okay, any other questions?
Just to follow up a little bit on that, may that offer some reasoning justification for having these non-owner occupied situations up for review on an annual basis? Or does that have its own problems?
Commissioner Arnson, this is Director Karnowski. We talk a lot about the enforcement. I mean, you can put a lot of things on paper and then tell your staff to enforce it. And there's just a sense where there is just not enough time in a day for us to be enforcing everything to the T. In this situation, we would, and as I think required now in the zoning code, we have to maintain essentially a registry of existing tourist rooming houses within the city, but they are allowed to operate. I think it would be more prudent for us to put within the zoning code that, yes, on a calendar year basis, so at the start of January, all of the tourist rooming houses within the city receive a review, for example. So, I mean, that's something to think about, and that's something that we could definitely look at. But I think at the end of the day, we've got to consider what are the collective goals as the community. There is an argument that let's say if you're in the core of the city in Alder Nable's neighborhood or Alder Jennings neighborhood, and a house goes for sale for $60,000, and someone purchases it and renovates it and then rents it to as a tourist rooming house. Think about the stability factor. If that house has historically been utilized as a single family, now you're bringing in people and they're coming and going each weekend or each week. There is some merit to the discussion that, is this something that we want to continue to promote if you're non-owner occupied? If you look within the draft ordinance that you have in front of you, there is a provision to allow for up to 30 days in a calendar year that you don't have to be present. It has to be your principal address, your primary address, as identified through something like voting registration. And there is some flexibility in there where if you want to rent your house out for a week and not be present, you're able to do that. But there is still some responsibility that comes along with it, where if there's issues at the property that we could put this in the code itself as well, that it's reviewed every year. And let's say we wouldn't renew it on an annual basis or something like that. So I think there are other avenues to go and there are other ways to do it. We just have to be cognizant that, we need to be up on the registry itself and reviewing police reports or any neighborhood concerns that come in as a result thereof. But again, if you look at the base of it, with the use itself and the neighborhood stabilization, I do have some concerns that our end collective goal is to reduce the number of rentals in the city. Why would we continue to encourage something like this, or how can we regulate it to the point where it's not a detriment to the neighborhoods?
Okay, any other comments? Any other comments? Okay, Director Karnowski, I'm not sure that you have a whole lot to go on at this point. I have mixed feelings about it. I don't think that tourist rooming houses in and of themselves are a problem. I think, much like Commissioner Ray said, if there's a problem, there's loud parties, there's cars driving across private property. Those are things that can be addressed through our existing ordinances. I don't know that it happens a lot. I know there's accusations that fly around, but I also don't see police reports. I can also understand Alder Jennings' comments. At what point do you just say, I'm done calling the police, they never do anything anyway? I don't know that they would get there very easily. I think if these people who see these things happening are willing to show up at meetings, as some have, offer testimony, as some have, a simple call to the communications center when these things happen is warranted. If they're doing something illegal on these properties, you need to call the police. That's the way it's supposed to work. Now, they may be gone by the time that they get there, and I don't have a good answer for that. I'm not sure what the police protocol is in regards to that. However, we created a chronic nuisance ordinance just because of that. Calls for service from the police department over a certain period of time can invoke the chronic nuisance ordinance. So again, we have something to fall back on in that regard. We have the condition or the standards of review. If it is a tourist rooming house that has been detrimental to the neighborhood, I think that's grounds to revoke the conditional use. If it violates any of the conditions, that's grounds to revoke the conditional use. I think rather than assuming something is going to fail or become problematic, it would be most prudent for us to let them prove it to us. Let us see that it's a problem, and we can address it when it comes up. The fact that some neighbors don't necessarily like it is not under what we would call a standard of review. There has to be some grounds for that. That being said, the draft ordinance that you have proposed, allowing no more than 30 days of non-owner occupancy, maybe that works. Maybe that's the direction we want to go. But I don't think that outlawing the tourist rooming houses in general is a direction that we should consider going. Tourist rooming houses provide a certain market, and I think we have the ability to regulate where that market is and how that market is presented to the public, whether it's an overlay district or in our specific zoning code as it is now. But I can tell you that the Convention and Visitors Bureau, especially in light of this COVID-19, we've got hotels that are less than 2% occupancy. That means we're not getting a whole lot of room tax next quarter, which means the Convention and Visitors Bureau is going to lose a significant amount of money from something that we already have been told we don't have enough hotel space to get large events. So it's a balance point that we're going to have to figure out, and the director gets the daunting task of doing that. If anyone has any comments in relation to the tourist rooming houses, either currently on the calls or someone watching at home at a later date, contact the Community Development Department over the next couple of weeks and get your comments in so we can have a draft ordinance to at least look at for next month's meeting. Director Karnowski, anything to add?
Not at this time. I would just ask that, review the draft ordinance. If you have anything else you want to see added or changed, we'll try to get a couple of options here. But I won't schedule this for a public hearing then in May. We'll continue the dialogue and really hone in on how we want this ordinance to take place and how it's going to shape out. So.
Okay. All right, then the next item that we have is the March 6th, the March 2020 monthly report. Director Karnowski, page 87 of your packets, Commissioners.
Okay, so surprisingly, even with the COVID items, we have not had any significant decrease in the number of monthly permits that have been issued. Today, we're actually over in the number of permits that have been issued as compared to the 3 previous years. So you look at the valuation, obviously 2018 was a significant year, and we can't really use that as by comparison, but, we're right on par with 2017, 2019, and the year-to-date fees collected is pretty on par with everything going on. There were a few, 1 single family, 2 0 lot line duplexes, and then 1 2-family. That's the new one on Main Street at the corner of, I think it's Illinois and Main. So then, of course, the Berkshire Apartments on Water Street did receive some of their permits as well. So with that, nothing too significant or staggering.
Okay. Any questions for the director on the monthly report? Okay, then the item number 7 is the staff update. Director, back to you.
Okay, so in our search for the next Kyle Kearns, the Associate Planner Zoning Administrator, we did receive 90 applications for this position. We have narrowed it down to 4 that the interview team will be bringing and doing a Zoom interview next week. Just as an update for the Plan Commission and for anyone who may be so inclined to watch at home during their pure boredom of being at home all the time, the assessing department's remote inspection department is still available for commercial and exterior residential inspections. All interior residential inspections are currently being scheduled for 8 to 12 weeks out. Neighborhood improvement is continuing, although we are focusing on some of our major cases. And so I know Mark, our neighborhood improvement coordinator, is down. I would say 1 to 2 times a week right now. After complaints are received, he's coming down and inspecting them as he can. economic development planning and zoning, we're all working remotely. We are working just remote. So if you have any questions or comments, you can shoot me an email or give me a call. The Fox Theater RFP was issued on March 16th, 2020. Proposals are due on June 12th, 2020. We have walked 3 potential developers through the property this in the last 2 weeks. So there is some interest. As most of you know, there was some additional contamination, coal cinders on the Northside Yard development site. Staff and Merge worked really hard on the amendment because we were right up against, they wanted to break ground. We needed to get the amendment signed. I mean, there's all sorts of crazy stuff going on, not to mention this pandemic. So we worked through it, and we did come to an agreement consistent with the City Council's directive and the Finance Committee's directive. And so the amendment to the development agreement has been executed as part of that. You should see some more activity at this site in the coming weeks, provided that there's no scaling back of construction part of pandemic orders. The footing foundation permit was issued. They did start doing some geopier and removing some of the contaminated soils late last week and into this week. The Berkshire Senior Housing Project on Water Street is well underway and is currently on schedule. And then the Wanta Live Work Units, as a quick update, all the plans, and this has kind of been our hang up, have been submitted at the DNR for review of the remedial action plan and the stormwater management plan. We've begun to look at the development agreement, and hopefully we'll bring it forward in the near future for consideration. Obviously, the big thing that we have to work on is transferring the property, but making sure that these 2 items that are currently with the DNR are reviewed and approved. With that, I believe that's the rest, everything that I have. Good news is we are down a truck now, an inspection truck. That employee got into an accident today, and they are at home recovering just fine. But I would remind our comptroller treasurer, if he's on, that we would like a new pickup truck at some point.
Yeah, that's not going to happen. No. All right. Well, thank you very much, Director Karnowski, for the staff update. Any questions on the staff update from anyone in attendance? Okay. With that, our agenda is exhausted. Thank you, everyone, for participating. I think our first teleconference meeting went very well. I appreciate you all joining in. And until next time, we are adjourned at 7:52. Thank you very much.
A video of this meeting is available for viewing on the city's website, stevenspoint.com/videos.